myself. My name is Agata, and today I have the privilege to represent the claimant, which is Farla Alevamento in the case at hand. Members of the tribunal, generally speaking, there are two parties to a sales agreement, and both of them have certain obligations. In the case at hand, the claimant held its end of the bargain by delivering the frozen semen despite the hardship that was caused by the imposition of tariffs. However, when the time came for the respondent to perform its part of the obligations and to renegotiate the purchase price, it conveniently shifted all the risks upon the claimant, contrary to the spirit of the agreement and the contract law. And therefore, with regard to the contract adaptation, the claimant has two submissions to be made. That firstly, the claimant is entitled to seek contract adaptation under the hardship clause, as the imposed tariffs fell under the scope of hardship, and also the contract does provide for a remedy such as contract adaptation. And secondly, independently from the contractual grounds, the claimant is entitled to seek contract adaptation under the contract law, and that is the CISG gap filled by the provisions of the UNIDROIT principles. Starting with the first submission, it is the claimant's position that the imposed tariffs fell under the scope of hardship. The tariffs were introduced by the government in Equatoriana, that is the respondent's place of business, amounted to 30% of the price increase, and were a result of retaliatory mechanism against the actions undertaken by the president of Mediterranean. To put it simply, President in Mediterranean imposed a 25% tariff on products from Equatoriana, and Equatoriana retaliated by imposition of 30% tariffs on products coming from Mediterranean. The starting point of the contention between the parties is the hardship clause itself, and I kindly ask this tribunal to follow page number 14 of the record. Under clause 12, I will quote, it is stated, seller shall not be responsible, and the second to last line, hardship caused by additional health and safety requirements or comparable unforeseen events making the contract more onerous. In the case at hand, the imposed tariffs fulfilled all three requirements. They were comparable to health and safety regulations, they were unforeseen, and lastly, and most importantly, they made the performance of the contract more onerous for the claimant. Starting with the first requirement, in order to assess what the parties meant by the category as comparable unforeseen events, we must take into consideration the intent of the parties in line with Article 8 of the CISG, that is the contract law, in order to establish the meaning of such a term. The respondent was very much aware of the claimant's intention to what categories would be constituting the comparable category. And in order to prove that, I kindly ask this tribunal to follow page number 12 of the record. That is the email sent by the claimant to the respondent, and in the fourth paragraph it states expressly, we are not willing to take over any further risks associated with such a change in the delivery terms, in particular not those associated with changes in customs regulations or import restrictions. And at the bottom of that paragraph it adds, at minimum a hardship clause should be included into the contract to address such subsequent changes. Therefore, the claimant informed the respondent that it wanted to exclude from the sphere of its obligations restrictions with regards to transportation. Therefore, the tariffs should be regarded as comparable. And as to the second requirement, the tariffs were unforeseeable. The tariffs that were imposed by the government in Equatoriana came as a shock not only to the parties, but also to the experts and informed circles, especially due to the fact that both countries, that is Equatoriana and Mediterranean, are members of World Trade Organization. This organization provides for a dispute settlement mechanism and not retaliatory measures. One of the biggest goals of this organization is the commitment to lower customs tariffs, and therefore not to retaliate if there is a conflict between the countries. Moreover, it is also supported by the fact that the tariffs were not foreseeable in terms of the goods that were covered by the category as agricultural products. Even when the respondent's representative, Mr. Greg Shoemaker, inquired with the ministry whether frozen racehorse semen fell under the category of agricultural products, the employees in the ministry were not certain and it took some time to give the answer. Therefore, it was not within the party's power to actually foresee that such a particular tariff would also relate to the goods as frozen racehorse semen. And lastly, and most importantly, the imposed tariffs made the performance of the contract more onerous. The imposed tariffs amounted to 30% and destroyed the commercial basis of the sales agreement, which is to make profit. On the last shipment, the claimant lost its 5% of profit and sustained a loss in the amount of 25%. Also, I would like to relate to the...
Can I just,
of course,
because I needed some time to process what you said.
Mhm.
There is a question 23 here in the clarifications at page 58. And of course, there are several parts in this response. The question is whether have Mediterranean or other countries imposed comparable tariffs before. So my question goes to foreseeability. But I want to understand whether the last part with Mrs. Cecile Frankel had anything to do with the foreseeability.
It is the claimant's position that it did not. As prior to the contract conclusion, it is indeed correct that the president of Mediterranean stated it would be taking a more protectionist approach. However, the tariffs were never mentioned in any of the programs, and the scale and the goods that were covered by these tariffs came as a shock also to the experts and the informed circles. Therefore, it is the claimant's position that they could not have been foreseen. And also, even if the president of Mediterranean imposed such a tariff, nothing would indicate that Equatoriana would retaliate. Especially due to the fact that the parties are members to World Trade Organization. Firstly, they would at least try and attempt to resolve their dispute amicably and in the later stage impose such tariffs. And as to the third requirement, I would like to relate also to the external evidence that my co-counsel has asked the tribunal to admit. As it was pointed out, in the other proceeding the respondent has with a third party, the parties agreed on the ICC hardship clause, which requires for a threshold of making the contract performance excessively more onerous. In our case, the parties have agreed to a threshold of making the contract more onerous, and therefore a 30% of tariffs must be taken into consideration as making it more commercially difficult for the claimant to perform the contract. Also taking into consideration other factors, such as the poor financial situation of the claimant, it was found by such authorities as, for example, Professor Brunner or Professor Snyder and Davis, that the threshold of hardship generally can be lowered if a party is suffering from a poor financial situation. This is exactly the case at hand. Therefore, 30% may not deem as much at the first glance, however, it destroys the commercial basis of the deal and puts in danger the restructuring plan the claimant has with its creditors. And as to the remedy available under clause number 12, it may not expressly state that the parties are entitled to adopt the contract. However, again, we need to take into consideration the intent of the parties and the agreement the parties had. And such an agreement is confirmed on page 17 of the record. On that page, we can see the witness statement of Ms. Juliana Pravnik, that is one of the claimant's lawyers. And in the fourth paragraph, she states, I will quote, I mentioned to Mr. Antley that for us it was important to have a mechanism in place which would ensure an adaptation of the contract for the unlikely event that the parties could not agree on an amendment. Mr. Antley replied that in his view that it should probably be the task of the arbitrators to adapt the contract if the parties could not agree. Therefore, preliminary, the parties have agreed on a remedy such as contract adaptation, even though the clause itself does not expressly provide for such a remedy. Also, if the parties do not agree on the contract adaptation, that would make the hardship clause dysfunctional. There would be no remedy available to the parties in cases of hardship. and the most common remedy for hardship objectively is contract adaptation, as termination of the contract seems to be too far going, too excessive, and not in favor of the parties' wishes. And as it comes to the second submission, it is the claimant's position that irrespectively of the contractual grounds, the claimant is also entitled to seek contract adaptation under the CISG gap-filled by the provisions of the UNIDROIT principles. The starting point of that would be that Article 79 of the CISG does govern hardship under the notion of impediment beyond the parties' control and not merely the impossibility events. It was found by numerous scholars and also in case law that Article 79 also covers the events of hardship. For example, in the Advisory Council's opinion, number 7, by Professor Brunner or Professor Schwenzer, and also in cases, that is the SCAFM International versus Lorraine Tubes, which was heard by Belgian Supreme Court, where the court has found that the basis for hardship are Article 79 of the CISG. However, for gap-filling purposes, in terms of the remedies, it turns to the UNIDROIT principles as general principles of international commercial contracts. UNIDROIT principles in Article 6.2.3 provide for 2 stages of remedies available to the parties. The first stage is the renegotiations of the purchase price, which in the case at hand have failed as the respondent refused to take part in any renegotiations with regard to purchase price. Therefore, we are left with the second stage, and that is either termination of the contract.
But there was a discussion at some point. There was I'm not sure if you call it an understanding. I think that's for you to tell us exactly what was there. And the shipment could have been stopped at that point, correct?
That is correct. However, the respondent created an impression of acknowledging that there was the need for contract adaptation. And after the claimant shipped the goods and wanted to renegotiate the purchase price, the respondent CEO, and I kindly ask to follow page number 18 of the record. And that is the final paragraph where it states, when confronted with our discovery in a meeting of 12th of February 2018, Ms. Kyla Espinoza, respondent CEO, got very angry and aggressive. She shouted that she was fed up with the permanent additional request from Farlab, which in her view had no basis in the contract and was no longer interested in further cooperation. Therefore, the renegotiations had failed. And the second stage under the UNIDROIT principles is either the termination of the contract if the parties cannot reach an agreement, or contract adaptation. The respondent has already resold, despite the resale prohibition in the agreement, some of the doses to third parties. Therefore, termination is no longer an option.
We delivered.
That is correct, we delivered. However, it does not impact the general occurrence of hardship. Hardship as a notion does not prevent the party from performing the contract. That is the force majeure. When there's hardship, it is economically unreasonable for the parties to perform the contract on the basis of existing provisions. And therefore, we are asking for contract adaptation to reinstate the equilibrium of the contract. And contrary to any possible arguments that were already raised in the answer to the notice of arbitration, the parties never derogated, even impliedly, from Article 79 of the CISG. The parties included hardship clause into their contract not to derogate from general provisions of the CISG, but rather to modify the effects in relation to certain events, that is health and safety regulations, and comparable unforeseen events. They lowered the demanded threshold. Derogation from Article 79 would need to represent real and mutual intent of the parties, which is lacking in the case at hand. The parties even took a step further, and in the choice of law clause, they chose Mediterranean law, and they made an addition including the CISG. Such an addition was not necessary, as the CISG is applied automatically, and therefore they wanted to confirm that the CISG as a whole, without any derogations or exclusions, was governing their contractual relationship. And as I am aware of my time, I will briefly conclude my both submissions. Members of the tribunal, each contract entails a certain risk, and it is up to the parties to decide on the allocation of that risk. This is exactly what the parties did in the case at hand. They included the hardship clause into their contract, and therefore the claimant is entitled to seek contract adaptation under both grounds. First, the contractual one, and also under the provisions of the CISG gap filled by the UNIDROIT principles. Thank you.
Thank you very much, Counsel. Counsel for Respondent will have 1 extra minute
Thank you, Madam Presiding Arbitrator.
to match the time.
Thank you. Dear members of the Arbitral Tribunal, good afternoon. My name is Dominique Kouvouts and I was speaking